My program tonight is based upon questions we continue to receive at the association. Many of these have to do with either audit issues or comments made during the board and pharmacy inspection. I am not an attorney, thus I do not offer an opinion. My comments related to the statutes enacted are based upon my involvement in the drafting of the legislation or meeting with legislators during the legislative process. So on the screen you'll see two depictions of one is the Michigan Public Health Code, actually just a portion of it dealing with the occupational regulations section, and the Code of Federal Regulations. And these are two of the three sources for the laws and regulations regarding the practice of pharmacy. Obviously, the third one that is missing here is the Board of Pharmacy Administrative Rules. Well, let us begin. I know that I have mentioned this several times during my previous presentations, but would like to again discuss about the Controlled Substance Act, the Federal Controlled Substance Act. And the CSA is unique. Unlike the Public Health Code or the Board of Pharmacy Administrative Rules, which are administrative in their function, the Controlled Substance Act is unique in that it is a criminal act. And it is specific in that it stipulates acts pertaining to controlled substances that are permissible. This is, significantly different than Michigan's Public Health Code, which is permissive. So it is incumbent upon pharmacists, pharmacy technicians to understand both the Controlled Substance Act, the Code of Federal Regulations, the Michigan Public Health Code, and the Board of Pharmacy Administrative Rules to know exactly what can and cannot be done. Actions against licensees can be criminal, civil, or administrative, and actions taken by the federal government can result in loss of license, up to and including imprisonment at times. And these can result in the inability to participate in any federally funded programs such as Medicare, Medicaid, or TRICARE. And therefore, again, I cannot stress it enough to keep up with not only federal law, but state law. As always, could be differences between both state and federal laws, and it is always the stricter law that one has to comply with. Reminder that pharmacists may contact prescribers, and this is due to our role, not as policemen, but to ensure that both the prescribers and pharmacists are compliant with state and federal regulations. And a reminder again, and it's always that when laws conflict between state or federal, it's always the stricter law that applies. Again, pharmacists need to understand that they have to have familiarity with both Michigan and the Controlled Substance Act, DEA, Code of Federal Regulations. Interesting, when you look at the Code of Federal Regulations in section 1306, under the purpose of issue of a prescription for a controlled substance to be effective must be issued for a legitimate medical purpose by an individual practitioner acting in the usual course of his or her professional practice. The mere fact that an individual may be licensed and writes a prescription does not necessarily mean that that prescription is valid. The responsibility for the proper prescribing and dispensing of a controlled substance is upon both the prescribing practitioner with a corresponding responsibility with the pharmacist who fills the prescription. An order purporting to be a prescription issued not in the usual course of professional treatment or in legitimate and authorized research is not a prescription within the meaning and intent of the Act. And a person knowingly filling such a purported prescription, as well as the person issuing it, shall be subject to penalties provided for violations of the provisions of the law relating to controlled substances. Additionally, a prescription may not be issued in order for an individual practitioner to obtain controlled substances for supplying that individual practitioner for the purpose of general dispensing to patients. And I continually get questions from pharmacists how to handle orders from physicians, prescriptions written for office stock. And our answer always is that if it is a Schedule II substance, it can only be issued through a 222 form. The physician, the prescriber, must issue to the pharmacy a 222 form asking to purchase the Schedule II substance. For all other controlled substances, it should be transferred via an invoice process, just the way when you purchase from a wholesaler. And a further reminder that a prescription may not be issued for detoxification treatment or maintenance treatment unless the prescription is for a Schedule 3, 4, or 5 narcotic approved by the Food and Drug Administration specifically for use in maintenance or detoxification treatment, and the practitioner is in compliance with the requirements as outlined in the Code of Federal Regulations. So I know there have been issues with Suboxone, Subutex, and such. If they are using it for detoxification, they must comply with Data 2000, that they must have both the XDEA number plus their own DEA number on that prescription. And note, those substances or those prescriptions cannot be delegated to any other individual, example, mid-level practitioner, by that physician. They are the only ones that can utilize that X number and take care of patients in that means. So let's delve into some of the definitions to get a better understanding. In looking at the Code of Federal Regulations, the CFR, and the definition specifically relating to controlled substance is the definition of pharmacist. And according to the federal code, a pharmacist means any pharmacist licensed by a state to dispense controlled substances. And it shall include any other person, and specifically they say a pharmacy intern, authorized by a state to dispense controlled substances under the supervision of a pharmacist licensed by such state. And this is critical to understand the relationship between pharmacist, pharmacy intern, and technician in practice. The Michigan Public Health Code also defines pharmacist to mean an individual licensed under this article to engage in the practice of pharmacy. And pharmacy intern or intern means an individual who satisfactorily completes the requirements set forth in rules promulgated by the board and is licensed by the board for the purpose of obtaining instruction in the practice of pharmacy from a preceptor approved by the board. And the Board of Pharmacy, in their rules, states that a controlled substance shall be dispensed by a pharmacist or pharmacy intern in the presence and under the immediate supervision of a pharmacist. So again, it is critical to understand these definitions and keeping in mind the federal definition that it is only a pharmacist, pharmacy intern, because they are licensed, that can dispense a controlled substance Additionally, remembering that in the Controlled Substance Act, it tells you that what you can do. It is not permissive, it is very restrictive. Only those things that the Controlled Substance Act says can be done are the only things that can be done under the law. Additionally, I wanted to talk about mid-level practitioners, because again, we have some issues in Michigan. There is a significant amount of confusion related to mid-level practitioners, and a lot of this has to do with a recent change in the public health code. And I continually get questions from pharmacists, pharmacy technicians, physicians, physician's assistants, and nurse practitioners or advanced practice nurses related to this. And under the federal code, mid-level practitioner means an individual practitioner other than a physician, dentist, veterinarian, or podiatrist who is licensed, registered, or otherwise permitted by the United States or the jurisdiction in which he/she practices to dispense a controlled substance in the course of their usual professional practice. Examples of mid-level practitioners include, but are not limited to, healthcare providers such as nurse practitioners, nurse midwives, nurse anesthetists, clinical nurse specialists, and physician's assistants who are authorized to dispense controlled substances by the state in which they practice. Understand that in this definition of dispense in the federal code, it means to prescribe, not actually to dispense. This is critical because mid-level practitioners are only authorized to prescribe controlled substances under delegation in Michigan. They have not been issued a state controlled substance license, therefore they act under delegation. And specifically with nurse practitioners, it seems that since the federal law has required them, or the DEA has required them to obtain a DEA registration, they are of the mind that they are independent in prescribing, and that is not the case at all. They are still prescribing under delegation. And actually, when you look at the definition of prescriber in the Michigan Public Health Code, the MCL stands for Michigan Compiled Law, Section 333.17708, that's found in the pharmacy and drug control portion of the Public Health Code. It defines a prescriber as a dentist, a a doctor, an allopathic doctor, an osteopathic physician and surgeon, an optometrist, a podiatrist, or veterinarian. But it also goes on to state that a prescriber is another licensed health professional acting under the delegation and using, recording, or otherwise indicating the name of the delegating licensed doctor of medicine or licensed doctor of osteopathic medicine and surgery. Therefore, for the purpose of writing or prescribing controlled substances, those mid-level practitioners, advanced practice nurses, clinical nurse specialists, physician's assistants, when they prescribe that controlled substance, they must not only include their name, their credentials, so that you know whether they are a physician's assistant, nurse practitioner, as well, and their DEA registration, as well as the name and the DEA registration number of the physician that is delegating this authority to them. Now, another issue that we find deals with electronic prescribing, and more specific with fax prescriptions. And I know that in Michigan law, it talks about an electronic signature being used in a fax prescription if it is sent from the prescriber's computer to the fax machine of the pharmacy. This now only pertains to non-controlled prescriptions. In the Code of Federal Regulations, the CFR, it defines paper prescription to mean a prescription created on paper or computer generated to be to be printed or transmitted via facsimile that meets the requirements of Part 1306. And Part 1306 tells the manner of issuance of a prescription, what elements are on there. Therefore, fax prescriptions under federal code not considered electronically transmitted prescriptions. Additionally, in the Michigan Public Health Code, it states that an electronically transmitted prescription does not include a prescription or refill authorization transmitted by telephone or facsimile machine. Now, in the past, in the administrative rules, there was a rule related to faxed prescriptions, and it stated that it must include the name of the pharmacy to receive this fax and the date and time of transmission. That rule no longer exists. The board years ago changed that definition, or changed the heading from fax prescriptions to electronically transmitted prescriptions, and thus by both the federal code and the state statute that says fax prescriptions are not electronically transmitted prescriptions, that rule no longer applies to fax prescriptions. The other issue that you need to understand with a paper prescription that is delivered by fax, since it is not electronically transmitted, an electronic signature is not. That prescription must be manually signed by the practitioner, by the physician, the individual authorizing that prescription. It cannot be signed by the nurse, the receptionist, or anyone else signing the prescriber's name and indicating their initials. It must be manually signed by that practitioner. So moving on, looking at the DEA website, they issued rules in 2010, and I apologize, this is a wordy slide, but it's just to show you that in the DEA diversion website, under the Federal Register, there's a notice of rules related to agents. And I wanted to just talk a little bit about the role of the agent under the Controlled Substance Act. An agent is not granted the permission to prescribe. This is something that practitioners, they themselves must do. A prescriber can never delegate to an agent or any other person the practitioner's authority to issue a prescription for a controlled substance. Now, the practitioner acting in the usual course of his or her professional practice must determine that there is a legitimate medical purpose for a controlled substance. An agent may not make this determination. So, who is an agent of an individual practitioner? The CSA defines an agent as an authorized person who acts on behalf of or at the direction of a manufacturer, distributor, or dispenser. And again, under the CSA, the term dispense includes prescribing. Establishment of an agency relationship consistent with the Controlled Substance Act is guided by general common law of the agency. For the purposes of explaining the law of agency as it relates to a CSA, it is appropriate to refer to and consider as generally applicable the restatement of agency, which provides that it is a fiduciary relationship that arises when one person, a principal, in this case the prescriber or the practitioner, manifests assent to another person, the agent, and that the agent shall act on the principal's behalf and subject to the principal's control, and the agent manifests assent or otherwise consents to the act. Therefore, an agent is just acting or providing services for that principal, in this case the prescriber. And again, keeping in mind that that prescriber cannot delegate the act of prescribing. All they are doing is asking this individual to perform certain functions for them. Medical determination of need for a controlled substance prescription cannot be delegated. Again, so it's not the agent that's making the determination to prescribe a controlled substance. They are just transmitting that prescription to the pharmacist or pharmacy on behalf of the prescriber, but making that determination. And that the elements of this valid prescription must be specified by the practitioner, and these cannot be delegated. Communication by facsimile or all communication of valid prescription for a Schedule 3, 4, or 5 controlled substance may be delegated to the authorized agent. So a practitioner or a practitioner's authorized agent may transmit a valid scheduled controlled substance prescription to the pharmacy, but they are not in themselves prescribing. They also can write the prescription, but they can prepare that prescription for that practitioner's signature. They cannot sign it for them. Now, there are some times when a fax prescription can be utilized for Schedule 2 substances. And in these instances, that fax prescription serves as the original written prescription. These cases are in the case of a individual who is in a long-term care facility, a fax of a Schedule 2 controlled substance would be valid and serves as the original prescription, but it must be documented on the prescription that that patient is a resident in a long-term care facility. There are two other instances. One, if that patient is receiving intravenous pain medication, then a fax prescription can be used as the original prescription for a Schedule 2 narcotic. And again, the difference being long-term care, Schedule 2 medication, patient receiving home therapy or intravenous therapy, it's a Schedule 2 narcotic. And then a patient that is in hospice, they can fax a prescription which serves as the original prescription for a Schedule 2 narcotic, and it must state on the prescription or indicate on the prescription that that patient is in hospice or is terminal. So in summary, the acts that an agent may take in connection with controlled substance prescriptions, an authorized agent of an individual practitioner may prepare a written prescription for the signature of the prescription, of the practitioner, provided that the practitioner, in the usual course of professional practice, has determined that there is legitimate medical purpose for the prescription and has specified to the agent the required elements of the prescription. Where a DEA-registered individual practitioner has made a valid oral prescription for controlled substance in Schedules 3 through 5 by conveying all the required prescription information to the practitioner's authorized agent, that agent may telephone the pharmacy and convey that prescription information to the pharmacist. And here again, going back to that definition of pharmacist in the Code of Federal Regulation, it's limited to a pharmacist or pharmacy intern because they are the ones licensed by the jurisdiction, in this case the state of Michigan, to accept that prescription. Additionally, in Michigan law, it states that the pharmacist will immediately reduce to writing an oral controlled substance prescription transmitted to them. And again, going back to that definition. And then the third is an agent in situations in which the individual practitioner has issued a valid written prescription for controlled substances and the regulations permit the prescription to be transmitted by facsimile to the pharmacy, the practitioner's agent may transmit the practitioner-signed prescription to the pharmacy by facsimile. So these are the roles of an agent related to controlled substance prescriptions. To go over that once again, prescriber versus agent, only the DEA registrants prescribe controlled substances. Therefore, a physician, a dentist, podiatrist, a mid-level practitioner under delegation. A prescriber can never delegate the DEA number or their signature to anyone else to use or to sign for them. They can delegate the transmission of a prescription via facsimile or an oral prescription for Schedules 3 through 5. An emergency Schedule 2 prescription that is transmitted orally must be from the prescriber himself to the pharmacist. It can never be transmitted via an agent. And then again, the prescriber only orally transmits to a pharmacist. Whereas the agent may prepare a prescription, may communicate it, but never anything to do with a Schedule 2 prescription. So moving on, I want to discuss two bills that were signed into law this year, or with this legislative session. So it was either last year or this year. The most recent is Public Act 209 of this year that was signed into law this past July. And this legislation revised the definition of prescription and references to prescription transmission methods. In it, it allows a prescriber to designate an agent who could transmit a prescription to a pharmacy. Michigan law was silent, and based upon comments we were receiving from pharmacists due to audit issues, such, we felt that it was important to put this into the public health code to be consistent with federal law and allow that an agent could transmit this prescription to the pharmacy. This bill also allows a prescription contained within a patient's medical chart in a health facility or agency to be transmitted to a pharmacy. And here specifically, if a patient is being discharged from one medical institution to another, aka from a hospital to a long-term care facility, to help facilitate patient care, the discharge orders from the medical institution can serve as an original prescription for the pharmacy that is taking care of the patient in long-term care, as long as those medication orders are signed by the prescriber and such. And it also eliminates the issue of more than 4 prescriptions on a form or such related to when a patient is being transferred. It also puts in Michigan Public Health Code what it is that a pharmacist can change on a controlled substance prescription. Again, this was brought about by the DEA making changes in what a pharmacist can change on a controlled substance prescription. They vacillated. At one point, it was broad what a pharmacist could change on a controlled substance prescription. Then they changed and said that 4 and 5. Then they said, well, it could also apply to Schedule 2 with the caveat if the state allows it. And we decided that rather than take a chance, we would ask to have this included in the legislation. So now a pharmacist can change certain elements of a controlled substance prescription, Schedules 2 through 5. And these include the dosage form, the dosage strength, the quantity, the directions for use after consultation and agreement with the prescriber. Keeping in mind the 3 elements that a pharmacist may never change on these prescriptions: the patient for whom the prescription was prescribed, the prescriber's name or signature, and if it's in the case of a multiple Schedule 2 prescription, the do not fill date. Those 3 elements can never be changed by the pharmacist, and this is again consistent with the DEA regulations. Now, last year, Senate Bill 841 was enacted, created Public Act 210 of 2011. And this legislation, when originally introduced, was to assist with providing care for individuals being treated by mid-level practitioners. And specifically, it was to broaden the ability of mid-level practitioners, physicians' assistants, nurse practitioners, advanced practice nurses, clinical nurse specialists, nurse midwives, such to prescribe Schedule 2 substances. Prior to this, based upon the Public Health Code and the administrative rules of the boards of medicine and osteopathic medicine and surgery, physicians' assistants and nurse practitioners, advanced practice nurses, were limited in the amount of controlled substance Schedule 2s that they could prescribe, both in quantity and locations from which they could prescribe these substances. The bill, when enacted, was meant to change it for all those practices, all those mid-level practitioners. However, once introduced, the nurse practitioners asked to have them removed from the language. They had concerns about the way the legislation was introduced, so they asked specifically that they not be included in this legislation. So the intent then was to allow physicians' assistants to prescribe Schedule 2 substances, eliminate the restrictions related to quantity or location, to require the name of the delegator and delegatee on the prescription, as well as the DEA registration number. And this was put into code, so it's very specific. And then to require the name of the prescribing individual to be on the prescription label. Therefore, if the prescription is written by a physician's assistant, that physician's assistant name is listed as the prescriber, not the delegating physician. And this was done specifically because oftentimes, maybe not so much with the physician's assistant as with nurse practitioners, there is not a relationship with patient with that delegating physician. The patient may only see that nurse practitioner or that physician's assistant, and it became confusing for patients and led to a lot of comments to their legislative representatives and such. So the intent was to require the name of the prescribing individual on the prescription label. The intent, as I stated, was to include this for all physicians' assistants, an issue came up when what was originally drafted was then introduced as the final bill ready for enactment once it went through all of the committees, and the section related to physician's assistants that are working under delegation from an osteopathic physician was omitted accidentally. The bill was signed by the governor last year, and unfortunately because of that, this change of physician's assistants' ability to prescribe Schedule II substances regardless of quantity or location from which they are prescribing is limited to PAs only prescribing under delegation from a MD, an allopathic physician. It's a technical issue. However, because in statute and because in rule there were still these restrictions, this has to be changed. There is a bill currently introduced, Senate Bill 1145, which will grant the same privileges to a physician's assistant prescribing under delegation from an osteopathic physician. However, I should say additionally, the boards of medicine and the boards of osteopathic medicine and surgery are also in the process of rescinding those restrictions in their rules related to this delegation. And keep in mind, this only applies or will apply to physician's assistants, since nurse practitioners asked to be removed from this legislation. The other critical thing, and why I stress this, is that one has to peel back the onion and look at the public health code. And I know this is a hard example to see on the screen, but as you look at the public health code, there is a section specific to pharmacy, medicine, osteopathic medicine, dentistry, nursing, etc. And again, this change related to the delegation of the prescribing of Schedule II substances was only made in the allopathic or medicine section, and therefore that is why it no longer or it does not apply to those under the acting under delegation from an osteopath. And this is just a copy of the notice that went out and is posted in the physician section of the state website, and it talks about expanded scope, but when you examine it and gives you the section that have changed this provision for physician's assistant, it's only in a section under medicine, again, allopathic medicine, MDs. Labeling, again, just want to reiterate that the name of the prescriber or the delegated prescriber is to appear on the label. So, in summary, I wanted to talk about, can a pharmacy technician take a verbal prescription via the telephone from the prescriber? And again, because the DEA defines pharmacist as only that of a licensed pharmacist or a pharmacy intern, the DEA does not permit pharmacy technicians to accept verbal prescriptions for Schedules 3 through 5 medications via the telephone. Telephone authorization of scheduled prescriptions, again, because a pharmacist may dispense this pursuant to an oral order made by an individual practitioner and promptly reduced to writing by the pharmacist containing all information required for valid prescription, except for that signature of the prescriber. And this is in the pharmacist manual published by the DEA. So it's very clear that there are restrictions on the ability of pharmacy technicians to take verbally controlled substance prescriptions via the oral means or via telephone. In your handout, I've provided to you a chart with the type of signatures required, again, to help alleviate any issues related to fax prescriptions, computer to fax, fax to fax, manual prescriptions. And hopefully you'll find this of assistance. Again, as we start looking at electronic prescribing and such, the question keeps being asked is, when can I start processing electronic prescriptions? When can the pharmacy prescribe that? Until you receive a indication from your computer vendor that they have been audited by an independent third-party vendor that has been approved by the DEA and states that your system complies with all of the federal regulations related to the e-prescribing. Until you receive that, any prescription that you receive electronically, regardless whether the prescriber has been approved or not, with an electronic signature, are not valid. So keep that in mind. Talk to your computer vendor to find out where they are in the process, how soon. I know that a couple of the chains have been approved. We are checking with the medical society related to physicians. But it's not only the independent physicians or such, but keep in mind that those that are employed by medical institutions or upon discharge, that hospital system has to be approved also and such. So there are a couple issues that need to take place prior to that. And again, until you receive this authorization or certificate, you cannot accept the prescription electronically. Again, I've included in your handout a reminder about the professional responsibility of pharmacists, and this again deals with actions or activities of the pharmacy inspectors related to going into pharmacies, and when pharmacists delegate acts, tasks, or functions, that it has to be under their personal charge, and that there must be certain things that have been accomplished by the pharmacist prior to delegating. And those are that you have to determine the knowledge and skill required to safely and competently complete the specific act, task, or function to be delegated. Before delegating an act, task, or function, make a determination that the delegatee has the necessary knowledge and skills to safely and competently complete the act, task, or function. This is most important. The third one is provide written procedures or protocols or both to be followed by the delegatee in the performance of the delegated act, task, or function. So it doesn't say you can or should, it says that you will provide these written procedures. And then you have to supervise and evaluate the performance, provide remediation of the performance to the delegatee if indicated. And then lastly, understand that anything you delegate to an individual, that you as the delegating pharmacist bear the ultimate responsibility for the performance of delegated acts, tasks, or functions that are within the scope of delegation. So the mere fact that you've asked someone to do something, whether it is to fill that prescription, enter it into the computer and such, you must have a policy and procedure manual outlining how it is to be done. You have to make that determination when the individual is performing this function, is capable, take remediation steps if necessary, and understand that you ultimately, as the pharmacist, have responsibility. I've included some websites, the DEA diversion website. There are some publications here that are of great value. The Pharmacist Manual, excellent resource to review federal regulations. And additionally, there are two other manuals on there that you may find value. One is for a prescriber and the other is for mid-level practitioners. Share that with individuals that are providing maybe some issues for you. And it also then provides access to the regulations found in Title 21 or the Code of Federal Regulations. Currently, what is going on in Lansing? There are five pieces of legislation that I wish to discuss a little bit, only in that there is a House bill related to the over-the-counter tax on prescriptions. It was introduced into the House this spring. We are hopeful that before the legislature leaves next week, that they will pass this out of the House. It basically changes the definition of prescription drug in the tax code to be consistent with that in the public health code, and therefore end the requirement of collecting sales tax on any prescription that is dispensed with an over-the-counter item. Legislation on pharmacy technician licensure. In reality, this legislation will probably not pass this year, but this would require pharmacy technicians to be licensed. It would also require them to be certified. There is a grandfather clause for individuals that are currently employed in a pharmacy that have met certain requirements, and that the pharmacist that they are working under attests to the individual's competencies. There is a House bill dealing with opioid technology that we have been opposing, that would require for any opioid that meets certain technology to prevent abuse, either to be snorted or injected or such, that a pharmacist could not dispense a generic without written authorization of the prescriber. We concerns with this because of the impact that may have on patient care, as well as it puts certain onus on the Board of Pharmacy to compile a list, and the FDA has not even done that as yet. And so we just see this as onerous on pharmacists, provides poor health care for the patient, and is really an issue related to a drug that is coming towards the end of patent to protect the manufacturer. There is a bill introduced to allow advanced practice nurses independent authority. This would make the advanced practice nurse, clinical nurse specialist, clinical nurse midwife or such, provide them the ability to practice without having to have a delegated relationship with a physician. They would be independent practitioners. They would be required to get a state-issued controlled substance license and give them all of the authority that a physician has other than surgery or procedures such as this. And the last thing is that we have been informed today that as of tomorrow, there will be a bill introduced into the state Senate related to pharmacy audits, and basically a pharmacy audits Bill of Rights. It would mirror the agreement that MPA has reached with the Michigan Association of Health Plans related to how audits are conducted, looking at extrapolation, other issues, and such. And so we are hopeful that it will pass at least the Senate this year, and then obviously will have to be reintroduced next year, but at least we have a bill that will be in written format and introduced. So we are very hopeful of this. Lastly is just that, again, some websites for the Michigan Department of Healthcare license to obtain access to the public health code, the administrative rules, the Board of Pharmacy's phone number. Keep in mind that this is a general number. It just goes to a phone system, phone tree, and you may or may not get a response, but you can certainly leave a message there. And again, keep a reminder that the Board of Pharmacy and the professions now come under LARA, the Licensing and Regulatory Affairs. They are no longer under the Department of Community Health. So if you've had these websites bookmarked in the past, you may want to look at it to make sure that you are going to the correct website.